Call this meeting back to order. If you're finishing your sandwich, keep eating.
But don't talk with your mouth full.
Don't talk with your mouth full. Yeah, that's right. We're on agenda item 22. Dental Board of California Sunset Review Report 2018. Karen?
Okay, so what we're going to be doing is reviewing each of these 18 issues. These were the issues that were brought forward during the board's last sunset review period. This document actually will be part of the document that we're submitting by the end of the year, so I thought that if we could get it essentially approved and out of the way today, it's one less thing you'll have to read, and we'll just piece it together. So I'm going to go issue by issue, and the explanation of how this is laid out. The issues were identified by, I'll call it the Oversight Committee, because the Oversight Committee or the Sunset Review Committee is made up of Assembly people and Senate people. And so their committee staff identified what the issue was, gave you the background, and when it says staff recommendation, it's referring to the oversight staff's recommendation. The red is essentially our response now. We had an interim response that was essentially, we're going to be doing this, and now the response is to report out what actually occurred. So issue number 1 is pretty simple. We requested the authority which had to be given to us through statute, meaning a bill had to go through the legislature and signed by the governor, to give the board the authority to collect email addresses for licensees, dentists, and registered dental assistants. We received that authority in AB 179, which was our sunset review legislation last time around, and you can find that authority in Business and Professions Code 1650.1. Are there any questions?
Karen, does everybody know what sunset review is?
Well, that's a very good point, Yvette. Thank you for bringing that up. So I did try to go over this with the new board members just briefly when I met with them, but it doesn't hurt to go over it again. Every 4 years, all boards within DCA go through a process whereby we present a background report and submit statistics for the previous 4 years to the legislature. And the legislature reviews all this background information that we submit to them, and this is how they come up with identification of the issues and what their recommendations are. The template doesn't really change much. All boards are responding to the same questions year after year. Anthony Lum, the executive officer of the Dental Hygiene Committee, mentioned that he's going through his hearings now, so they're a year ahead of us. So he prepared his report last year, and they're going through their hearings. We're going to be preparing our report and submitting it this year, and our hearings will be in March. The hearings essentially are when typically the executive officers and the board presidents go in front of the legislature and answer any questions they may have and discuss the report. Then legislation is introduced to essentially reinstate the board's regulatory authority and licensing authority for another 4 years. So in essence, our expiration date is January 1st of 2020. And so during the 2019 legislation goes through the process and is hopefully signed by the governor. And so effective, we can continue to do business from 2020 to 2024. All boards go through this process. It is a good opportunity to review where we've been the past 4 years. The statistics will be presented in a way where by year, so you can see the statistics as we bring it forward. So getting back to this this is considered section 10 of the report. It's the discussion of prior issues that were developed. So again, back to issue number 1 and receiving our authority. Did anybody have any questions? Okay, good. We'll move to issue number 2. which essentially was regarding the Dental Assisting Council. Should the board examine ways to increase the availability of examination? What is the board's relationship with the council, and how can the council become more effective? Hopefully you've read the background information. I don't think there's any need to go through that, but the committee staff's recommendation was that we should explain why the board recalibrated the RDA exam and the decline in the pass rate after the practical exam was recalibrated. Now, for the new board members, we went through much discussion. We were having many issues with the registered dental assisting practical examination. In the end, the board decided that to not move forward with revising or having a practical examination, so that'll be brought forward during the sunset review period. So going through the response, basically what I tried to do was outline what has occurred since then, what we did in response to the fluctuating pass rates. The Dental Assisting Council determined that an occupational analysis of the RDA profession must be conducted. That was a decision made with the council and the board. We conducted that occupational analysis, and based on the occupational analysis, then we had the RDA examination reviewed, and the Office of Professional Examination Services assisted us with that, and through many meetings and input from stakeholders, it was ultimately decided that the board determined that it was not necessary to have a practical examination in order to issue licenses to RDAs. So basically this in red discussed how we went through the occupational analysis, where we've been, and where we are now. So we say some of the other questions that were asked, the board should explore ways to improve relationship with stakeholders and to empower the Dental Assisting Council to better serve its role in vetting and making recommendations on the dental assisting issues. The Dental Assisting Council has existed since 2012, and it's been off to a little slow start. So we're hoping that with the influx now of new members to that council, they will start to feel comfortable with taking on some of these issues and discussing them as a council and bringing recommendations to the board. In the meantime, I think the board worked close. I can say positively that the board worked closely with the Dental Assisting Council through the last 2 years by having joint meetings with the council. And this was hopefully to help the council feel more comfortable in participating in these types of meetings and to share information together without the council having to have a separate meeting and then bringing recommendations forward to the board. So it was a procedural sort of a procedural decision that was made that we would have a number of joint meetings so that the discussions could be made between the council members and the board at the same time. And I think that that was useful. Now we're hoping moving forward that the council will be able to feel strong enough to handle some of these issues on their own and then to bring forth recommendations to the board. Does anybody have any questions or concerns about how the response was written at this point? Any? Okay. Yeah, how did you want to do that, Michael? We have 18 issues. Did you want to take public comments?
It's up to the chair. If you want to save it for the end or take it after each one.
Might as well take it after each one.
Take it after each one. Dr. Felsen.
Go ahead.
Felsenfeld, CDA. Just a quick question. Would the combination of the RDA written and the law and ethics fit into this area too to facilitate the ease of getting things done relative to the dental assistants?
I'm not sure I understand your question.
We are combining, or you are combining the RDA written and the
Right.
law and ethics together, right?
Right?
Wouldn't that be something that would go into the same general category of making it a little more facile for the dental assistants to get their their credentials?
Well, that's probably an issue we'll actually discuss in the background paper itself,
Okay.
as we review the program changes that have occurred since the last, so this discussion pretty much is just focused on the specific questions that the committee had answered. I'm sorry, the committee had asked last time. So, yes, Dr. Felsenfeld, I think that it would be appropriate to put in the background paper that we're doing.
That's all.
Okay.
Thank you.
And just to remind the new board members, so what's going through the process now is that the RDA written examination and the law and ethics examinations are combined. We went dark this Monday. I think we went dark on Monday, and so the new examination will be issued soon. So we will be reporting these things as essentially changes in programs that have occurred since last time, but that's in a different place in the report. So if there are no further questions, we can move on to issue 3, delayed implementation of the Breeze contract. This is, essentially, we didn't have much of an update on this other than we went live on Breeze on January 19th of 2016, so essentially we've been utilizing it for 2 years. We didn't, while there were plenty of challenges in doing so, it doesn't really make much sense to itemize those challenges or to keep talking about how it didn't work like we thought it was going to work. We're doing the best with what we've got, and we're making it work. So that's pretty much how, what the response says to issue number 3. Any questions or comments? This is too easy. Okay, pro rata, we've had this discussion periodically. What is the impact of pro rata on the board's functioning? Pro rata is required. We don't have a lot of say. We have no say, essentially, in what we pay. There's a formula. I can say that the department has been working with the boards to talk about whether certain services could or should be eliminated, what services are essential. So the department is spearheading discussions about pro rata, and basically that's what I've gone on to say. Essentially, we're looking at the issue now, and we'll report back if something comes out of it. We move into the section on budget and staffing issues, and issue number 5 is relating to the dental fund condition. And if you just jump down to the staff recommendation, the board should share the fee audit with the committee as soon as the information is available and determine the appropriate fee caps for licensees. We made the audit report available. It still remains available on the board's website. And from the audit, we determined that we were going to periodically have audits of the fund to see whether or not certain efficiencies could be made to our process. So basically, that's how we responded. Essentially, we had the audit. Part of the question here was whether or not we should combine the dental fund and the dental assisting fund, and the board researched this and brought it back to the board. The board staff determined that merging of the 2 funds will streamline certain processes, and the combining of the 2 separate funds and 2 separate appropriations into one will create efficiencies in budgeting and accounting processes in the long term, and would make any budgeting issues simpler to understand. So at the May meeting last year, May 2017, the board voted to support the merging of the 2 dentistry funds, and board staff will be working with the budget office to do that. So that's our response to that.
Question, Karen? What kind of efficiencies are we looking for by combining those reports? What were there top 2 or 3 things that stood out that would be streamlined or made easier?
Right now, we have to do a manual process where we have to bill the dental assisting program for services provided by the state dentistry fund relating to enforcement. So we would no longer have to do that. It would be a shared fund. We would constantly have to monitor. And there's potential, right now with the two separate funds, that one fund could subsidize another fund if things were not billed correctly. So just overall overhead costs, supplies, cost of doing business, may not be absorbed accurately by the other fund.
And this was detailed in the May meeting of 2017, so we can refer board members back to that agenda item a year ago. Meeting materials are posted on the website if you want to go back and either listen to the discussion on the webcast or to look at the board meeting material. Issue number 6 is the foreign dental school approval. And this one, I believe, is an important issue that we're going to continue to address, I think, even in the new items that we're going to be bringing up. The response that we made at the time still exists. Most of this background information still exists. We did attempt to get statutory relief, if you will. Senator Hill carried a bill for us 2 years ago, I believe. Unfortunately, it didn't go anywhere, and the bill would essentially take the board out of the business of approving foreign dental schools. So as I understand it, I've just given an update on how we responded last time, where it'd be awesome if De La Salle could actually complete the CODA process, and we can say they've got a school that's approved by CODA, and that would strengthen, I believe, our argument that any foreign dental schools wanting to be approved by the board would then need to go through the CODA process in order to do so. So I'm assuming that board, well, I'd like to hear your comments on how you would like to proceed. This is just a report of how we responded last time. I don't think the opinions necessarily have changed. And so, but I'd like to hear what you would like to see happen with this. And I think you have Fran would like to talk.
Fran, I'm sorry.
I would really like to see the board get out of the business of doing this. It is such a laborious process that basically falls on two people, in addition to the other board activities that they have some responsibility for. You know, there's a travel component. There is the infinite review of documents. I think one of the things that may have been a consideration before is that we don't have that much. But I think you could almost say one is too much in terms of what it takes to do it. So what I would like is, whether this is an issue or not next time, that we make this one of our issues to have them try to address.
Excuse me. I would like to applaud Fran's previous dissertation regarding our need to make some changes in this area. Since I have been a member of the board, I have been involved in site visit, in application, initial application for approval in one school and a reapproval for another school, and then reapproval again for that same school. And it is a laborious, time-consuming, intensive process, not only for a few board members, but also staff. I don't think we have had the luxury to actually log the number of hours that we spend in this process. I was really afraid to do that because I know this is going out in broadcast, but I will have to say that, that my university, my employer, has been very lenient in allowing me to spend hours that belong to them doing this kind of work for the board and for the state. And they're very cooperative. They've been very cooperative in that effort. But it is not something that I think that the dental board should be in the business of doing. Hopefully, we can get some legislation that can relieve the board of that responsibility. But I will say, at a minimum, if that legislation is not forthcoming soon, then we need to revise the institutional standards that are currently in regulation, that are significantly outdated because they have never been revised from their original entry into the regs. Now, they were at the time, and I wasn't involved in it, but I understand from talking to people that when they originally were entered into regulations, they were a reasonable facsimile of CODA standards at the time. Now, we have a history of how CODA has changed over the years, their standards. And there are multiple changes in CODA standards from that time to now. At a minimum, we need to be looking at the same measuring instrument to measure equivalency of foreign dental schools that are measured by U.S. dental schools. At the present time, our measuring instruments are not the same. Recently, I was told by our legal counsel that we were required to measure the educational application for the educational institution on the standards that are currently in regulations. And it really hurts me to say that's an equivalent education. I'll have to say it is not an equivalent education because those standards are not what schools in the United States are now assessed by. So at a minimum, we need to bring our institutional standards up to date, and at best, we need to get out of the business altogether.
Dr. Lay?
I'd like to echo the same sentiment as what Ms. Fran Burton and also Dr. Steve Morrow said. Yeah, having gone through this process a few times, I do think that, we really need to consider a different pathway for the approval of foreign dental schools. The fact that CODA does have that process right now, it is a pathway that foreign dental schools should take up, just like every new dental school in the United States has to go through. And I think we need to follow, that pathway. Whether or not the La Salle will pass the CODA accreditation, that should not be part of our consideration, really, because it is a pathway. And, I wish them the best, in their CODA process. But that should not be part of our consideration. We really need to move forward with, the update of institutional standards and really getting out of approving the foreign dental schools.
I just want to clarify my comment in saying that if De La Salle passes CODA, I think that strengthens our argument that foreign dental schools can get through CODA. There's been some criticism that foreign dental schools would never be able to get through the CODA process. So we're looking, it could be De La Salle or any other foreign school that could get through the process that I think would strengthen our argument moving forward. That, okay, this is up and running now, people are getting through the process and getting approved. And so we don't need to be doing that anymore. Dr. Chan, I think that this is where you had asked the presenters whether or not there were differences in our institutional standards that are on regulation and the CODA standards. And Dr. Morrow, I believe, answered that, but if you need further clarification, I'm sure he's available to say that. Now, I don't want, yes, the board wants to have its educational standards equivalent to CODA's, but I don't think you should imply that the current standards don't provide public protection. And Dr. Morrow, do you agree with that? While the
I agree with
standards we
that.
currently have may not mirror what we want to have to be in line with CODA, the current standards we have do still provide public protection.
Well, in some ways, excuse me, in some ways, the standards, the education, institutional standards that we have currently in regulations are more prescriptive than CODA standards are, because CODA standards do not identify the specific competencies that a dental education program graduates must possess upon graduation. CODA simply says, you tell us what your competencies are. We'll tell you whether we think they are appropriate. You show us how you are assessing that your graduates are competent. We'll tell you whether we think that you're doing a good job. But they do not identify 14 competencies. They say, you tell us what your competencies are. We'll tell you whether they're appropriate or not.
Dr. Chan, does that answer your question? Thank you. Okay, thank you for that input. Is there any public comment on foreign dental schools?
Hello. I agree with the CODAs that we should move with the CODA, but I would also like to ask, what are we going to do about the need for culturally sensitive dentists if we're going to remove our foreign accreditation at this time? We need more people that are sensitive to the communities that we live in. We need more Latino dentists. As somebody mentioned, 40% population, and we're only probably 2 or 6% dentists that are Latino or speak the language well. So how can we fill that need in our community if we're not going to do it through the foreign accreditation? And I wanted to mention, somebody said yesterday about the school in Moldova, and I just wanted to point it out that that school has 11 students that are Latino studying right now at this time. And those people are going to come back and fill that need of the population. So how are we going to do that? If we're going to, and I agree with the CODA. I do agree that we should move to CODA, but how are they going to fulfill that need for California?
Well, we'll, I guess, leave that.
I've been involved with a program called National Pipeline, can't remember now, National Dental Pipeline Program, and for a number of years, over 10 years now. And that program has been working really hard with the dental schools across the country to increase the number of underrepresented minorities in their enrollment. I believe that it is working, maybe not as fast as we would like to see, but I think it's working. I think it's not the job of the dental board to take care of that. It's really, it's IDEA, it's the dental schools that need to take care of that issue. It's not an issue of the dental board.
I'm not aware of anything in the admission requirements of DLSIA or Moldova that specifies that they need to be of any particular ethnic extraction. So I don't really see how those schools specifically help address that need any more than any other school. They all have, a diversity policy regarding admission. And I mean, if there is something, we'd like to know about it, I guess.
And also the fact that they do have international program that admits 30, candidates from other foreign countries outside of Mexico. We don't have the demographics of those 30 students. We don't know where they're coming from. they could be coming from Europe, Middle East, wherever. So, so I don't think that part will really help address the issue of the Latino patients who are underserved in our state. So having said that, I think that it is the responsibility of ADIA and the dental schools to address that issue and not ours.
And if I could, I think that I would say that, thinking about De La Salle, you've got 30 students a year. That's a hole in the bucket of what we need in California. In my opinion, it's going to take a joint effort of a number of things. We have for a number of years had a program of loan forgiveness for dentists who work in underserved areas. And it goes begging for people to get involved in that. But I think it's going to have to be a collective effort and not one that is limited to a school or two schools. It would take us forever getting there. We've got to attack this on all fronts. And how we do this, how we do foreign dental schools, is just a small part of that answer.
I would just like to know why CODA takes so long for the accreditation. I know they have to fulfill the requirements, but it seems like a very long time. And I know the Medical Association, they have like 1,200 schools that are already accredited or approved internationally by their organization. So it's just, we're way behind on that.
I don't know that we're way behind because we haven't had
CODA.
many foreign schools apply to us. CODA's process, from what I understand, is lengthy for all schools, American schools also. I mean, the process is very lengthy. I think why it may take more time, and we've lost our CODA representative because Drs. Lay and Morrow had to go to another meeting, but and we can refer this to another discussion, and I'm sure we will agendize it for the August meeting. But I mean, that was an interesting statistic that you brought up, that you know that there are 11 Hispanic students at Moldova, because I don't think we even knew that.
Yeah,
So
there are.
that's interesting. But of
Can
course, all students from all all students at Moldova be eligible to come to, that Moldova being approved now means that all its students from all the countries that attend there would be eligible to apply for licensure in California, assuming they meet all the other requirements, but their educational requirement would be met. So it wouldn't just be the Hispanic students, it would be students from all other different countries too.
Hi, Karen. I just want to raise a couple questions. Is accepting foreign dental school is the only solution? That's the thing that I look at right now. For Chinese populations in the Bay Area, we have a large Chinese population. And I understand a lot of dental offices, to serve Chinese population, they hire Chinese translator staff to translate. And that will fulfill the need. And I understand a lot of dental practice actually are slow, not seeing enough patient. Okay, so of course there's certain need for certain ethnic group. So besides looking into the foreign dental school acceptance, can we also try to improve by bringing in some people that can do the good translation and help out the existing dental office to accept more patients?
We'll write that down and see if there's anything that we can do. We will be agendizing the discussion of foreign dental schools moving on as also a new issue that we're concerned in. So it's going to be addressed here as a prior issue, but will also be addressed as a new issue. So if everybody's ready to move on, we'll go to item 7, which is occupational analysis for RDAs and EFs. Should the board conduct these? And we're happy to report that we did. We completed the occupational analysis for both the RDAs and the RDA EFs. And what this does essentially now has gotten us back on track as a board, because every so many years, the occupational analysis should be conducted on both, on all professions, and then our examinations are revised around those occupational analysis. So we have completed number 7. Number 8 is acceptance of additional regional examinations. This was put in because at the time ADEX was trying to get approval, and they were successful in getting legislation passed by AB 2331 in 2016. So essentially what we've been doing to respond to that piece of legislation is we have been doing, and ADEX agreed to pay for all the things that needed to be done before the board could actually accept its regional examination. So the first thing was to have an occupational analysis done of dentistry. That is in process right now. After that's done, then we do a psychometric analysis of the ADEX exam itself. And then through board discussions in the past, the board had indicated that it wanted to utilize the ADEX portfolio model or hybrid model, and so that would be done in regulation. So we still have a long way to go. So ADEX is not currently accepted in California, except as Dr. Morrow had mentioned earlier, licensure by credential, essentially with people having 5 years experience in another state, if they had taken ADEX as their regional examination, we are accepting that because we're just basing the licensure by credential pathway on clinical experiences over the last 5 years. So we're moving forward with that. On issue number 9, patient notification and record keeping, essentially the staff's recommendation, they were asking whether or not we thought we needed to have something in statute that required dentists to notify patients when they retired or when they sold their practice. And as we had mentioned in our background, the board, we really haven't received any significant number of complaints from patients about dentists selling their practices without notifying their patients and who subsequently end up harmed by the new dentist. So we don't really see this as an issue that needs to be addressed. Are there any comments or questions on this? Okay. Unprofessional conduct. This was sort of a glitch in statute that was found. Apparently there was a requirement in statute that professionals essentially couldn't treat their spouses or their family members, and the medical board was exempted out. And all these years, the dentists thought that they were also exempted out. So when it came to our attention, I believe CDA brought forth legislation to correct that. So this really wasn't our issue, but it was corrected. And essentially, Business and Professions Code, Section 726 was amended effective January 1st of 2016.
Karen, can I interrupt you just for a minute? Can we back up to 9 just for 1 second?
Sure.
It just kind of thinking out loud, it occurs to me that probably a lot of patients don't really understand what their rights are in terms of accessing their records. And I think it's fair to say that a lot of our dental colleagues probably don't know what the law is in regards to how to maintain, how to store, how long to store those patient records. So there is some, because it doesn't come up very often. You know, people have a practice for 40, 50 years, and then all of a sudden the issue comes up. I'm just wondering if there was something we could do proactively to have a link on our website to cover this issue, and if that would be an educational piece for not only our patients, but our dental family.
So the link would be for consumers letting them know that they have the right to request a copy of their dental record?
Yeah.
Okay, that is something that we will address. I think it's related to this issue, but this issue is specifically focusing on notification to patients of whether there's been a death, a retirement, a transfer of property, a transfer of a practice.
And I guess, I guess I would expect that piece to be covered by this link as well.
Okay, just to further respond, the board did try to undertake, I think we had a subcommittee, and Dr. Witcher probably would remember this. We had a subcommittee look into whether or not the board wanted to get involved with recommending a certain period of time for dental records to be held. And I think they decided that decision is left up to the dentist and his or her legal decision or the insurance provider. Is that how you recall it?
That is how I recall it.
Okay.
But I'm thinking that if that could be written down in such a way that the public and our colleagues have a better understanding of that.
Okay. I think we'll make a note of this, Sarah, and we'll see how we can best address it in the future. Okay. Any other questions about issue number 9, notification and record keeping? Okay. Let's see, we've gone through 10, unprofessional conduct. 11, ensuring an adequate and diverse dental workforce. So there was a lot of background information provided. In essence, our response is that we continue to collaborate with interested parties to assist in the implementation of the ACA and enhance efforts on delivering workforce shortages, including targeting any outreach efforts to underserved areas or communities. We continue to go into dental schools and let the graduating dentists know of the loan repayment program, that it's available to those who will agree to work in underserved areas for a number of years, in which case they would receive a total of $105,000 to pay down their loans. So we had the Center for Oral Health come and give a presentation to the dental board on workforce data. We collect survey data as a requirement for renewal, and they pointed out how we can enhance what we actually do with that data. We have not done that yet because we converted to Breeze. So in the future, the board will look at how to make this data that we collect more useful in order to address any workforce shortages out there. Are there any comments or questions about issue 11? Okay. Again, then, now we're moving into issue number 12, which had to do with our loan repayment program. We had some major changes to the program that occurred, and those have been documented here in the legislation that was enacted. We changed a number of things in terms of when the payments were paid out to the people working in these underserved areas. And essentially, I've outlined here what those changes have been. We'll continue to monitor whether or not we get additional applicants for this program, but we still have quite a bit of money in the account to be able to pay down a number of loans. Issue number 13 has to do with the difficulty of collecting citations and fines. And really, the only difficulty in collecting citations and fines is if in the course of the citations, if a license is revoked, then we are not able to collect cost recovery or citations. There was one particular case that really skewed our numbers where a dentist was eventually revoked, but in the meantime, he didn't produce dental records for like 40 patients. And then we charged them $5,000 per patient, and it got up to be $300,000 or more dollars. So that is still on our books. So it's really, we really don't have a problem collecting citations per se. We only have a problem collecting when their license is revoked. And the question is whether we would use the franchise tax board recovery. Typically, people with revoked license leave the state, and so there's really no way to collect the money. Fortunately, it's not a huge problem for us, other than we have one licensee where it was a huge amount of money, but we don't have a lot of licensees that are in the same situation. Okay, issue number 14 has to do with continuing education and should RDAs be audited. We've already started that process. We are requesting a budget change proposal to add staff. The process of auditing is very intensive, and while we've started the process, as I said, whether or not how robust we'll be able to go after this will be determined on whether we can add staff. Discipline case management timeframes are still exceeding CPEI's performance measures of 540 days. It's the same across the board, unfortunately, for all boards, and we're going to be looking closely at that to see how we can possibly bring those timelines down. I know that we've been focusing on older cases to try to clear those more quickly. Of course, we have elevated certain cases and continue to elevate the sexual misconduct cases, drug or alcohol misuse or abuse. We also aggressively now are working the cases relating to hospitalizations, reflective of notifications of Business and Professions Code 1680Z, and deaths, of course, are investigated quickly. So we are, I'm considering having an outside vendor come in and do a review of our enforcement program to see whether we do indeed need to hire more people or whether or not there are processes that could be changed to make us more efficient. So that's essentially how we've responded to this particular issue. I'm sure this issue will be, this is where they typically, where the legislature typically targets boards in our response rate. And we've indicated in the past what some of those reasons are of why we have extended periods of the process. After it leaves our office, it goes over to the Attorney General's office. I think Ms. Linda Schneider was here at the last meeting and indicated, you know, getting hearings set are out at least 6 months, and so that cuts into our time frame right there. But we all are working together as a partnership to try to get these cases settled more quickly. The dental board, I believe, is issuing more public reprimands than it has in the past. We are going to be having those numbers that we'll give to you during the statistics part of Sunset Review, so you'll be seeing that. So we're trying to settle cases more quickly so that we don't have to take them to hearing, and we're making every effort to try to get through the complaint process, through investigations, and the completion of the case more quickly. And we'll have more information, as I said, updated information we'll be bringing to you in the next meetings. So I've pretty much already addressed issue 16, enforcement staffing issues. Yes, we have a lot of cases. We're almost fully staffed now. Some of our backlogs can be attributed to having a lengthy process to hire our peace officer status employees. They have to go through background checks, medical examinations, psychological examinations. Those all take time. And so, again, we're considering having somebody come in from the outside and reviewing all of our processes to see how we might make improvements internally. on issue number 16, where they said, should the board consider conducting a staff and workload analysis? We do a staff and workload analysis as a regular basis. We also do desk audits of the cases. Our management team is reviewing the cases that the investigators are working on. Our subject matter expert pool has not increased, but we don't see that it's a serious problem. We can always recruit more. We tend to rely on the subject matter experts who we have had the most success with when they actually do go to hearing, when their testimony has been upheld. And I think the board currently has over 130 available subject matter experts to provide case reviews in order to assist us in the investigations.
I wanted to ask about the notion of a probation unit and not having the investigators do both. Where are we on that?
Well, I think that that would be covered in an, essentially an audit from an outside person to come in and look at our processes and determine, you know, whether a probation unit would be necessary. As I said, we're using more public reprimands, so we've been able to decrease the number of probationers that are out there and use probationers for in ways that perhaps wouldn't be where the discipline has occurred because of one case in the course of a dental career, as opposed to somebody who's established a trend of bad care or so we're trying to discern what would be more appropriate for probation, what would be more appropriate for public reprimand. So yes, a probation unit is on the table. A probation unit would require a budget change proposal. We would need to do the workload analysis to be able to do that. So that's why I thought that an audit of our processes may assist us and give us the data that we need to move forward. Certainly, establishing a probationary unit would be a possibility. We're almost done, folks. Okay, issue number 17 is low response rate to consumer satisfaction survey. And we've talked about this before. You know, I'm sure we all go and we have a good meal or something, we're treated somewhere with exceptional service. And my intentions are always good to go online and say what great service we had or experienced, and then I don't do it. So we typically hear only the bad stuff from people who aren't happy. And so we don't have a high response rate, period, to our customer satisfaction surveys. But the response rate when we do have it are essentially people complaining that it took too long or that the case didn't end up the way they had hoped. And so that's primarily what we hear. We have a few now and then that said, thank you very much, I learned a lot, people were very helpful. And actually I'm finding more and more that we're hearing people say, you know, they really appreciate how our staff assists them when they call and that their calls are being answered now. So, I mean, we have made improvements since the last Sunset Review period. We'll continue to try to see how we can reach out to people. Until we can bring those timelines way down, I think that we will continue to see a low response rate to the consumer satisfaction. And the last issue is essentially whether or not we should be continued to regulate the dentistry in California, and I think that you'd all agree that we would support that effort. So this section now will go into our background report. The background report has to be approved by the board, and so at the August meeting, we'll bring more information. We will likely, unfortunately, have to schedule an additional meeting to essentially go through what the final report looks like so that the board can put its can accept it and put its blessings upon it before it's submitted. I believe the submittal date is going to be December 1st, and our last board meeting of the year is November 29th and 30th. So we would need to review it and approve it prior to that date. As we get closer to knowing what our report is going to look like, we're hoping to be able to have a lot of the information to you at the August meeting. In the event that for some reason we can't, at the August meeting, we'll be asking for, try to find some dates that would be appropriate, either to have a teleconference or to have a meeting in Sacramento to be able to finalize our report. And that concludes this section. Does anybody have any questions? And if you haven't had a chance to read this, Yvette, I know you have. I'm counting on you to be my editor. Again, because you did such a good job last time. So anyway, we're done with that item, Dr. Stewart.
So we're moving on to what, 22B?
22B, and I'm tired of talking, so Sarah's going to take over.
But she's going to interject if needed. So item 22B are new issues for the 2019 legislative oversight hearing. So as Karen mentioned, we have the opportunity to address new issues and bring new issues forward to the legislature next year as part of our report and as part of the hearing process, and in a hope that perhaps we'll have statutory amendments made that would benefit our business processes. And so staff has been working on compiling issues that we've been encountering, specifically for this meeting, issues relating to dentist licensure in California. And so within our 4 pathways, we've had several questions that have come up and need further clarification. And after analyzing how best to approach making those changes, we've determined that what we really need is statutory changes first. So staff has compiled either a list of questions that need to have the board consider or recommendations for the board to consider. And so what I'm going to be doing today is walking through this memo here, and we will start with licensure by credential. Staff has provided a background of the current requirements, and then they've identified the issues. And so
A little more clarification. When you said that staff has identified that statutory changes need to be made first, that's how you're prioritizing versus regulations?
yes.
Could you go into that thinking a little bit so that all of us have a better understanding how that decision is made relative to this kind of an issue?
Karen, do you want to?
Well, because we're going through sunset review, we have an opportunity to see if certain areas that aren't very clear in statute now can be clarified in statute rather than opening up a regulatory package. You see how many regulatory packages we have, and that's a very lengthy process to get through it. So if some of these questions that exist because of what current statute reads, if we could get those sections just tweaked, it's quicker. And we would be able to resolve some of the issues and the questions, I think, more quickly.
So then help me understand, how do we tweak a statute?
Well, we explain what the problem is, we give the background, and then we write the language. Well, the Senate or the Assembly or the Oversight Committee, we would assist them in writing the language. It would go through the processes of both houses and eventually be signed by the governor.
And that's
Does
a
that make
faster
sense?
process than,
Well, it's a faster process only because we're going through sunset review. We could do this at any time if the board would secure an author to do this. It just happens that we have an opportunity now to put things into our sunset review legislation, but this could be taken up at any time. We don't have, we have sponsored our own legislation, and as a miracle, we were successful in getting a fee increased, which doesn't usually happen through an author and through statute. But we don't do it regularly So we don't have a lobbyist to help us. And so it would require just board staff essentially working the legislature independent of the sunset review process to get this done at another time.
Thank you.
So, I mean, it's an opportunity. Whether or not the Oversight Committee agrees with us and wants to take it up is another issue. So then, if the board is able to see what some of the questions and concerns are and recognizes that we need to find a solution, then sunset review is the first option. Finding an author on our own to take it up at another time is another option, or going through the regulatory process is another option. Does that make sense
That's
now?
helpful, thank you.
Okay.
Thank you, Sarah, for allowing me to interrupt you.
Okay, so starting with the first issue relating to licensure by credential, staff has outlined the current requirements and has identified what the current issues are, and they're numbered. So starting with number 1, specific to section 1635.5A2 of the Business and Professions Code, the current requirement for licensure by credential requires proof of a current license issued by another state to practice dentistry that is not revoked or suspended or otherwise restricted. So that's pretty broad, and you would be amazed at how many different scenarios we come up with applicants. And so as a result of the different scenarios we've dealt with applicants, we need to seek additional clarification. So starting with, does the dental license need to be issued by the United States, or would a dental license issued by a state within the country of Canada be permitted? It does not specify exactly in the United States. So that's the number 1 question. One of the bigger questions we get, what does otherwise restricted mean? Is it referring to disciplinary action? Would it be referring to specialty, faculty, or residency licenses? Do we want to exclude applicants that have a specialty license in another state? Do we want to consider making an accommodation for applicants that only possess a medical license issued by another state, such as oral and maxillofacial surgeons, the ability to apply through this pathway and apply their clinical practice time to the clinical practice requirement? Different states have different practice requirements. Many of the oral and maxillofacial surgeons are licensed by the medical boards in the other states rather than the dental boards. What status does their license have to have been in during the time which the clinical practice is being used for qualification within the section? Can they use only the clinical practice time while only possessing a residency license or another type of restricted license in another state if they have an unrestricted license at the time of application? So do we, if they've had a restricted license before or a specialty license in the past, are we only looking at the current active license that they have for qualification for licensure?
Now, I regret that Drs. Lay and Morrow aren't participating in this discussion, so we may have to bring it back to the August meeting, because I think that they have background that would be able to respond to this. But as an example of what does the term otherwise restricted mean, I'd like to just fill the new board members in, remind the seasoned board members that at some point there was confusion among our staff with the legal interpretations we got a number of years ago. And restricted somehow meant whether or not they just had discipline. What happened was there were 7 licenses issued. Actually, there were probably 14 total licenses issued to licensees from Massachusetts who were foreign-trained dentists and had restricted license, not related to discipline, but they had restricted in the true sense of the meaning restricted. They were had to be supervised and could only practice dentistry in a certain location. So that's truly restricted. Now, after 4 years in Massachusetts, they were required to either have gone through the appropriate testing procedures or whatever in order to get a full license. So we did issue 7 in error, and fortunately we have the authority to pull those back. The board has the authority to pull back licenses that are issued in error. A lot of other boards are actually seeking this authority because they've run into similar situations. Right now, the board staff is interpreting restricted to mean just that. If you've got a restricted license in another state, saying you're under supervision or you can only practice in certain spots, that's considered restricted. Also, if you've had discipline for some reason and it's restricted. But the big question in my mind that comes up is, in the last 5 years, more states have issued specialty licenses, which in some states means that they can only practice, say, orthodontics or oral surgery. And so would the board consider that a restricted practice? Because California does not issue specialty licenses. So in essence, if somebody from another state is restricted to practice orthodontics, if he or she comes to California, he would be able to practice whatever. Now, probably orthodontists would come to California and practice orthodontics. So I don't think that that's necessarily an issue to worry about patient care, but I don't think that when this particular piece of statute was developed that specialty licensure had gone that far, that it's restrictive in some states. And I'm guessing, though I would need to hear your comments, that you would not want to be restricting specialists from coming to the States.
I'd like to respond. You know, it's a huge issue because it used to be there were, 7 ADA recognized specialties, and their roles were pretty well defined. And when you went into some of the specialties, it was very unlikely that you would do anything else. That's not the case anymore. Now we have one other specialty board that basically has sued in a number of states to allow it to grant specialty recognition to things like oral medicine, orofacial pain, sleep dentistry, things where you're not going to be able to sustain a specialty license without practicing general dentistry as well. So the whole question of specialty recognition has become very murky. And I think the only clean way to do it, and I hate to say this because I would like to see specialty licensure for those people that really do function as specialists, but California, as you said, we don't issue specialty licenses. We only issue general dentistry licenses. And I think the only way to really resolve it is to go back to that, unless somebody can figure out, our specialty system, which has recently been kind of upended through litigation, and it has to do with right of commercial free speech and restrictions on various ways that people practice as being found to be anti-competitive. So the only thing to do is to go back to the default, which is really unfortunate, but that would be my feeling about it.
I'm sorry, the default being what?
Just issue a general dental license and they have to meet the requirements for general dentistry, meaning they would have to take the reb or come in by LBC with an hour requirement. Now, you could define time in residency, the hour requirements, and things like that to allow them to qualify, but they would, they would still need to meet those requirements for LBC outside of specialty recognition. This came up before because I know when the original legislation went through, there was a an attempt made at doing specialty licenses, and it got shot down during the legislative process as being unworkable because of the fact that California issues a license to practice dentistry, and there's always a chance that somebody could go back and practice general dentistry when they might be unfamiliar with doing that, having been in a specialty for a long time. It wasn't a very good way to resolve the issue, but that is what was done. And I'd really like to hear what Dr. Morrow, who's kind of in, in his position as Dean of Postdoctoral Education, he would have a good perspective on that. So like you say, I think it needs to come back. But it's not a simple issue.
So then, do we want to table LBC for August meeting then?
Yes.
Okay. So we will skip all of issue number 1. Issue number 2, starting on page 5. Licensure by residency. Staff has outlined the current requirements. Currently, the Business and Professions Code, section 1634.1C.
Sarah, I'm sorry to interrupt, but Dr. Lay is our sort of resident in this also, so should we table this? Okay,
I don't think we'll really be able to give it the kind of discussion without her that it
okay.
needs.
Can we pick a simple one?
None of these are simple.
Reb, or new license, we can do new license to replace canceled license.
Let's do that one. I think that one has a chance.
That's a fun one. Okay, issue number 4 on page 9, new license to replace canceled license. So, for the LCP committee, we briefly discussed this yesterday evening at about 6 o'clock. In 1961, Business and Professions Code Section 1718.3 was implemented. And this section allows licensees the opportunity to apply for a new license to replace the canceled license. So for the new board members, a license is canceled if it fails to be renewed within 5 years of its expiration date. So it will fall into a delinquent status for 5 years and then become canceled. The only authority that we currently have to issue a new license is for an applicant to apply to the board for a replacement license, and that has to go to the board, which is currently reviewed by the Licensure, Certification, and Permits Committee, and then a recommendation is made to the board. What we've received, at the time this was created, we didn't have all of the available pathways to licensure that we have now. So the recommendation, or the question right now, is whether or not the board would consider amending this particular section to allow applicants or licensees the option of either applying via the current method, or they can apply for licensure as a new applicant through one of the other available licensure pathways. I think Dr. Lai.
Dr. Lay.
Dr. Lai.
Dr. Lai. So my question is, okay, he's getting a little punchy. My question is, if someone is put on inactive, let's say they check inactive before the 5 years is up, what do they do? Is there a special pathway from there? Like if they put it, we talked about that at
Right.
first, for retired versus inactive. So they placed on inactive, and within 5 years, before 5 years, well, wait, then that 5-year issue doesn't count. Is that correct?
Correct. So the key piece to this is Dr. Lai is talking about. So licensees have the option, they can renew as active and current, they can renew as inactive, they can renew as retired, they can renew as disabled. The key piece to this is that they have to renew every 2 years. If they fail to renew in one of those categories, their license would fall into a delinquent status, and that delinquent status would last for 5 years. There's been a misconception out there that the board, once you renew in an inactive status, that you no longer need to renew on a biannual basis. The only thing that inactive status does is it no longer requires you to complete your continuing education requirements. So that's the only thing. You still have to pay your renewal fee, and you have to do it every 2 years.
Sure, because we've come across a few where the assistant thought they were inactive, and it was 5 years, it lapsed, and she'd moved, and so she had to do everything all over again.
Right.
So that was one of the situations.
We currently do not have a mechanism for any license status to just be put in a certain status code indefinitely. You have to actively renew your license in some sort of a status every 2 years.
So this piece of statute essentially penalizes somebody who received a California license, left the state, and now wants to come back because the requirement is to pay all the back renewal fees. Whereas a candidate who would be applying for licensure who never was licensed in California, coming from another state, would only pay the application fee for licensure by credential. So in essence, anybody having received a California license who leaves the state is penalized for coming back to the state.
Yeah, the renewal fees can amount to thousands of dollars.
And as you saw,
Yeah.
as Dr. Lai, or as you see in your closed session packets, look at the application process for all those canceled license asking for new licenses. The fees can be exorbitant, thousands of dollars. So in essence, we're penalizing somebody for having left the state. Now, as Sarah said, when licensure by credential was created, this section should have been amended at that time, and it wasn't, so that's why we're bringing it forward. And that's why it's important when we watch legislation to make sure that we're reviewing other sections of law that might be related, so that you can do it all at the same time.
Well, I don't see why there'd be any problem with having, pathways to licensure open. I mean, you could extend pathway A or pathway B. I mean, we have that kind of thing in other categories as well, where, pathway A might be LBC if they're coming in from out of state, and pathway B would be, the reissuing of a new license. I mean, that seems fairly straightforward. And they could pick whichever the fees were less. And, I mean, assuming the fees are based on the actual workload to staff, maybe there would.
Well, the fee they would have to pick which application pathway they would qualify for, so maybe REB, portfolio, licensure by credential, licensure by residency. On the RDA side, where we see a significant amount, they would essentially apply for licensure, complete all of their standalone course requirements. Most of them have already practiced as dental assistants, so they have the on-the-job experience, and then they would have to take the combined exam. So it would just be dependent on that applicant's qualifications and which pathway they probably would be best suited for, and staff would be able to help walk them through what those requirements are.
I mean, you would be hand walking a lot of people through it, but it would be a benefit to the applicants for sure.
We already do.
When someone leaves the state, let's just say they leave the state, they have no intentions of coming back. However, they have no intentions, or in the back of their mind, maybe they do have some intentions, and they keep up their application, they pay their fees, and do whatever to keep up their license, but they don't practice for 10 years. And we've seen this too. They don't practice for 10 years, but they're able to come back and practice. Now, but we've seen some who've left the state. They thought they had no intentions of coming back, but life happens after 10 years. They get divorced. They're coming back. And then they have to go through whatever it is that they have to go through to get their licensure. To me, that's somewhat of an inequity. I don't know if we're, where someone has not practiced and they're able to get their license, but they pay their fees. So it seems like, it appears as if it's inequity, but maybe I'm wrong. I could just like to leave this up to the professionals in the room to see if that is, because I think when we created this law or reg, then somehow this didn't seem as if it was taken into consideration. So I don't know.
Well, the inactive status is across DCA. So it's, all boards and bureaus have the same policy, if you will, or requirement, that if you continue to renew your license in an inactive status, it was, I'm sure, developed to allow those who decide to come back to work that essentially, because they've paid all the fees, it wouldn't be a financial burden, and all they would have to show is that they've been keeping up with continuing education. But you're absolutely right in that, they could have been out of clinic practice for a number of years, but that's the way things are set up, and that's across Department of Consumer Affairs boards, okay? So what we're looking at now is essentially somebody that has been practicing in another state for perhaps 20 years, and they got their California license 20 years prior and left the state right away. And now we're saying that other people in the same situation, not having a California license ever issued, would be able to come in through the licensure by credential pathway, paying the application fee, which I don't recall what it is, but I'll say $500, $600, $700, $800, not thousands of dollars. Okay, so there's two issues there, Yvette. There's the issue of, yes, it may seem not right that if somebody's kept up their license in active status and really not been practicing, we don't have any way of asking them whether they've been practicing. They essentially get to, if they decide tomorrow that they want to be active, they just have to show proof of continuing education and they're active. Now, I don't believe we've seen discipline come through that shows that there's an issue with that. But that part is across consumer affairs.
Let me just add a professional comment. If somebody has graduated and maybe decided they weren't going to practice anymore and decided to practice again and was inactive, I'm sure ethically they would go back and take courses, maybe their weekend or things they would practice before going to the public and actually doing it. I think most doctors in general will do that. So I'm not afraid to say that. Yeah.
Where are we?
Does the board agree with the staff recommendation to move forward as a new issue to include in sunset review?
Yes. I think we just need a consensus. I mean, do we need a vote for this?
Well, I think we need, my recommendation, Mr. President, Dr. President, is that these topics are open for discussion so that staff can get a better idea of what to do with it. Ultimately, you can vote on it when it's vetted out more.
Okay, right.
And when we have more information. But basically, we're bringing this up to hear what your comments are. I'm sorry it's late in the day on the second day of the meeting. And maybe we don't take it any further because everybody seems pretty, you're giving me that face like,
I got the last one's really easy.
Oh, if there's an easy one, let's do the easy one.
It's certification of proof of graduation for dental education. Essentially, right now, the current law just states that it needs to be the dean's signature. And as we know, all the dental school deans, they're very busy, but they do have delegates. And so this is just requesting a statutory change to allow the board the authority to accept a signature of a dean's delegate for purposes of licensure applications. Dr. Lai said no.
With a smile.
With a smile.
I think the dean should take responsibility and read it over and sign it.
Seriously?
It's supposed to be an easy one.
Well, unfortunately, the dean isn't held accountable. It's the candidate who's trying to get the license
So
get it.
the issue with this is the law and ethics examination application that we received for the dentist. we're receiving probably 800 applications for that, and it requires the dean's signature in order to allow them eligibility to take the examination.
Yeah, but I think the dean is already, he knows he has to do this. It's not like it's something new. What's this, I think,
We're finding a lot of
part of
times the
graduation,
deans will
right?
defer to their delegates.
I'm good with it, but I'm just saying, that's his job.
Michael has a comment. Going to take that.
For this particular one, I would recommend that you do a regulatory change, even though it looks like a statutory change might be quicker, just so you can retain the flexibility in 1634.1 about satisfactory evidence. Almost always when you see that phrase, it's a keynote that you're going to have a reg, because it begs the question, what is satisfactory? Who determines it's satisfactory? And if you eliminated that and just clearly stated certification from the dean or his or her delegate, you kind of will be boxed into only having that. And if you wanted to change it, again, that's going to be harder because it's out of the board's control. So that's why I would recommend that you just do a regulatory change on this one.
In this particular case, you could do the regs without going through, okay?
Okay, so then we will hold everything else for the August meeting.
Are you good with that, Dr. Stewart?
Okay.
Thank you, Sarah. Okay, where are we?
We're on item 23.
Carlos.
Thought you were done, Carlos.
Turn the whole Bible. Well, hello again, good afternoon, and we're at the end. So I'll try to push this through kind of quick. I know everybody has to catch some flights here. And so I'm presenting the enforcement statistics and trends for January 1st of 2018 through March 31st of 2018. Complaints received, 851. Complaints received, and they increased by approximately 8 cases for the last quarter. So that's a monthly average of complaints received. Quarter 3 was 284. Complaint cases open was 1438. And so the cases, we were at quarter 2, we were at 1460, so we're actually reduced 1438, and a decrease by 22. And so that's an average caseload for consumer services analysts of 260 is what they have on their desk currently right now. And on page 2, complaint closed, we closed 722 in the last quarter. And so we closed more cases in the last quarter. Quarter 2, we're at 655. So we closed more, but for some reason, it took us, we're slower at closing these cases. And so what we did was, as we look at complaint age, right there at 1 year, we were at quarter 2, we were at 242. And so we reduced at quarter 3 by 188. So that was approximately about 22%. So what we did is we got all the complaints, and the complaint compliance unit got together with all the managers so we could reduce the processing time. And so what we did, we started triaging, reevaluating all the cases, and we were able to close those cases out. And so as I spoke about in our last board meeting, it was in phases that we're going to do this to reduce all the 1 year's 9 to 12 month cases that we have case aging. So again, 722 complaints case closed, and again, we were slower. And so we're gonna identify this again. What we do is we identify the process with the managers, we do case audits, so we can improve the timelines here to protect the consumers. So the investigations case open right now, we're at 978. So we also reduced. In quarter 2, we're at 1,019, and currently we're at 978, so we're able to close cases. And so we have 978 cases open, and we have 74 inspection cases. And 74 inspection cases, that's all what the reporting at the dental office where they say that the conditions there are dirty, unsanitary. Those the 74 cases that are open currently right now. So we had a 4% decrease in open investigations. So again, we were able to reduce those numbers at Q2 with the 3 years of cases that we had of statute of limitations. We were at 67 and we were able to reduce that to 42. And so that only counts for 4% now. So again, we're working with the managers, investigators to reduce these timelines. So investigations closed, we closed 321. And again, we closed more cases out in the third quarter. At Q2, we closed out 163. So we closed out a lot of cases here. And I owe that all to my managers, and I owe it to the investigators and non-sworn investigators, analysts who was able to do this. And so we're at 321 total investigations closed. That's an average about 107 a month. So total number of investigations closed, filed with the Attorney General's office or filed with the District Attorney's office during the quarter was 52 cases. So we have the charts there so everybody could follow. So the average number of days to complete an investigation during the third quarter was 563 days. So it was 9 days slower. Again, we were closing a lot of cases, but we were slower at doing it. But we're identifying that with case audits and meetings with the managers. And so we had 24 citations issued for the third quarter, which was an increase. Last quarter, we're at 16. And so again, with the accusations, we had 18. It decreased, and the reason is citations are higher, accusations are lower, is because once we get these cases, like Karen and I will have a meeting, and we'll dig deep into the complaints, and what we do is a case-by-case basis. We start looking into, okay, what is the history of this dentist? The other thing is recommendations that we take into consideration is through the dental consultants. What is their recommendations? Other recommendations that we get is from the Attorney General's office. So when we sit down, we intake the recommendations, the complaint history, then we'll determine, yes, this is a case to go for a citation, or this is a case that goes to the Attorney General's office. So we're trying to reduce the cases that are going to the Attorney General's office and have more focus on those, the important ones, and send those to Attorney General's office. So currently, there was 52 cases were referred to the Attorney General's office, and as of now, there's 156 cases pending as of March 31st of 2018 with the Attorney General. The highlights here was there were approximately 198 open probation cases at the end of the third quarter, and that's 3-month average for disciplinary cases to be completed. So this was 1,086 days faster. No, I'm sorry, this was 186 days, and this was 136 days faster than the previous quarter. So we did really good on that, on disciplinary cases getting settled. So that's a plus for us. And when we get into the performance measures, we're going to see that in our performance measures where we decreased our days with the Attorney General's office. I know I'm kind of going through this kind of fast. Anybody have any questions? As we move into page 6, as complaint allegations, so we're still at incompetence, negligence, we're still at 51%. The cases, allegations that we're receiving. But from Q2 to Q3, it did reduce. So it was 6% decrease on the allegations we're receiving for incompetence or negligence. Anybody have any questions? Yes. 3B. So 3B, that's where we decrease what I was just talking about. The majority, again, is incompetence and negligence. And we have to remember, that's what's coming in to the dental board. But once this goes through a dental consultant, once this goes to an expert, it might not merit negligence or incompetence. So as it kind of decreases. I know it's a lot, but some of these cases don't merit that, and we close those cases out. Yes. So non-jurisdictional is when we receive complaints and all they want is a refund. They just don't care. Some are, they don't like the treatment they receive, but all they care is we want a refund. And again, we're not in the business to get refunds for the patients. Yeah. And other, yeah, I'm sorry.
I just looked at substance abuse, reports from substance drug.
I'm just curious if it goes from 0 to 40 substance abuse, drug-related abuses. Is that reported by staff?
So substance abuse could be reported by staff. It could be reported by another professional. And the other thing is what we call subsequent arrest reports, where they're convicted for substance abuse, drug-related charges or alcohol. That's where we get these.
Oh, this includes alcohol, like DUI and things.
Yes.
Thank you.
Carlos, couple things. First, could you explain the difference between and the consequences of simple negligence versus gross and repeated acts for our new folks?
Sure. So, and it's in Unprofessional Conduct 1670, and where it states we have negligence and incompetence and gross incompetence. Is that what it is? Gross negligence, I'm sorry. And so what it is when we get these complaints, the dental consultants will review it, and they could come back and say, you know what, there is some negligence, and what they categorize it as simple negligence, when they say, well, they failed to chart a simple treatment on their charting notes, which is just one act of negligence. And so therefore, we consider that simple negligence, and we close that out. So once we get into the incompetence, and the competence is where they don't know what the procedures are, they're not following, they're not, how could I say this, the proper procedures that they're doing, since, I'm sorry, not a dentist, but what I read. So they're not following the proper procedures, and so they'll categorize that as incompetence, where they fail to do a root canal. They leave an instrument in the canal, and they fail to tell the patient that it's in the canal, that'll be, considered incompetence. And gross negligence is just when we have a slew of treatments that didn't perform properly, and that's where they failed to follow any kind of procedures that they learned, or that should be followed as protocol, and it'll be considered gross negligence.
So what percentage of complaints actually go on to discipline, roughly, just approximately?
As for incompetence and negligence,
Yes, that category specifically.
I
So
would
you
have
have
to
about
get- yeah.
51%, and this is pretty consistent. You're not gonna, I mean, it fluctuates up or down a little, but that's by far always been the largest category as long as I've been on the board. I mean, the other categories are much less common, I guess is the point. But out of those, how many actually go on to discipline? Because
I would say out of those 51%, I could actually say we're probably looking at anywhere between 30 and 40%.
yeah,
still moving.
it's a fairly small
Yeah,
percentage.
Very small
yeah.
percentage.
So we kind of focus on the worst of the worst.
Yes.
Earlier in non-jurisdictional, you said that the complainant wants a refund, but we don't do that. But haven't we had cases where the refund could be a part of the judgment? Haven't we had some?
Well, in some criminal cases that we deal with, we can't ask for that, and it's victim restitution. But as far as mine is with administrative cases, we don't ask for that. For a refund, we don't ask for that.
We don't have the authority to ask to require the dentist to reimburse the patient. And there's probably a number of reasons why we don't go down that road. Part of it is, reimbursement of the patient would require you to show what your expenses were, not just for the dental treatment, but anything else that may be happening. And we typically don't have the staff to be able to do that. But I believe most other boards don't get involved in the financial aspects either of complaints. We're primarily looking at quality of care issues not getting pulled into the financial part of it.
Yeah, we will recommend for them to seek an attorney or to go to a superior court and seek advice through small claims.
Okay.
Yeah, a lot of times there will be a parallel case going through the civil system. If it's a really sizable thing, of course, it's got to be big enough to make somebody willing to take it on contingency. But, you know, we have seen civil claims of several $100,000 paid out, and then discipline also follows, usually later. So, and then, of course, they can always go to peer review.
Yes, that is true. And sometimes when we refer that, they call us and they say, well, an attorney doesn't want to take our case. And so what they do is they submit a complaint with the Dillon Board, hoping that we could get a refund for them.
Carlos? I wanted to ask you about the legalization of marijuana. How does it affect substance abuse?
Well, with us, it's, we don't have a specific section for that, but it's unprofessional conduct for a dentist to be practicing under the influence. So that it's considered unprofessional conduct. But we don't have a specific section now because it's not legalized to say, per this section, you're in violation. But it'll be considered unprofessional conduct. Yeah. Any more
Is
questions?
there any public comment? Seeing none?
So we'll move into 23B, and that's the third quarter, it's performance measures that we report to DCA. And so we were able to run quarter 1, 2, and 3. So as you remember, the last board meetings, we weren't able to produce these, but we have them now. And so it's to ensure the stakeholders that can review the board's progress towards meeting the enforcement goals and targets that were developed, so we could show these to the consumers. And so through, we are on target with our performance measures through the quarters 1 through 3. And so on quarter 1, we received 941 complaints, and that's a monthly average of 314. And so the complaints we got was 784, and the convictions were 157. So those convictions have gone down through quarter 2 to quarter 3. So at quarter 2, again, quarter 1, we're at 157. The next following quarter, it dropped to 98. Then the following quarter, quarter 3, it dropped to 89. So that's really good news. Would I like to see that number at 0? That would be in a real perfect world to see the convictions that we're getting, you know, licensees to be at 0. So in so PM2, so I'm looking at quarter 1, PM2, it's intake cycle time, and that's the number of days when we receive a complaint. We have 10 days to acknowledge it, send it out to the consumer saying, yes, we have your complaint, and it's going to be, you know, forwarded to, it gives the explanation that it'll go to a dental consultant, then it'll go to an investigation, so we have 10 days. And so we actually are below the target date of 7 days. So we have a target of 10, and we're at 7 days that we're doing this. So in quarter 2, we kind of went back up, and we missed our target date, and we were at 12. And the reason we were at 12 is between those months, we had 3 office technicians, 2 were in training, and so we only had 1 office technician who were sending out these notices. And so once they were trained, we had 3, once they were trained, so then in quarter 3, we dropped back down, and we're at 8 days, so we're below our target dates for that. So then on PM3 investigation cycle time, and that's where we were doing good, but we're at 270 days, and our actual days was 216 days to complete the process, to complete an investigation that wasn't transmitted to the Attorney General's office. So our target date was 270, and so we're doing really good. We're at 216 for quarter 1, but then our average started going up to 249 in quarter 2. Then in quarter 3, we missed our target dates, and we were at 291 days. And again, the reason is we had one sworn investigator position open that's been vacant, and we're going approximately about 2 years. So that started catching up to the investigators as well, all this caseload. And then for a period of time, we were short a special investigator in the Orange office. So with those vacancies, those cases started catching up to us. And that's why we went over the target dates. But again, so once we fill these positions, we'll bring those dates down. So that was the reason we went over the target dates. So then with formal discipline, I'm looking at PM4. So right here, we're able to reduce the days. So we have a target date. Once we complete an investigation, we forward that to the Attorney General's office. And at that time, we start counting the days, that how long it takes to close formal discipline, to get adjudicated. This also includes discipline, or when we withdraw cases, it's still counting those days. And so in quarter one, the target dates is 540 days. So in quarter one, we're over it. We're over the target dates. We're at 1,335 days. But then in quarter two, we reduced it. We're at 1,128. So in quarter three, we reduced it again. So now we're at 962 days. So that's really good that we keep reducing these days. We're still below our target dates. And so we've been all working together. And one of the reasons, and we've been changing our process. So we identified that, yes, we have to work on this. We changed our process. One of the things that our days were counting negatively was because we had cases at the district attorney's office that we submitted. And so we're waiting on a conviction. So we're waiting on those convictions so we could prep our cases and send it to the Attorney General's office. And so that was accumulating a lot of days there. And we identified it. We had to have a meeting. We changed the process. And so what we did is some of those cases, we kind of failed to check up with the district attorney's office. There's some miscommunication. Some cases were already adjudicated. So we got the information so we could send to the Attorney General's office. And there was cases that we sent to the Attorney General's office, and we were just waiting on the conviction from the district attorney's office. So we got all that information. We were able to pass that along to the Attorney General's office so they could communicate with the district attorney's office, because obviously we want to, burden them making, how can I say this? We don't want them to speed up their process, and where our case, because our case is clear and convincing, theirs is beyond reasonable doubt. So there's two different philosophies there. And so that's the case. We put them in contact so they could work together on timelines. So we were able to do this. And the other thing is now with the work group meetings that we're having with DCA, all across the board, all the boards are not meeting the target dates. So it's not just the dental board. So it's all the boards. So with the work group meetings now, they're going to reach out to the to the Attorney General's office. They're going to be invited to the next work group. So that way we can all have a discussion on the process with all the boards, their process, work together, come to some solution so we could reduce these dates and start meeting our target dates. So that's the good news there. So then also with PM 8, that's probation violations cycle times. And that's the number of days of when a violation occurs and it's assigned to an investigator. So there's 15 days that we have to get in contact with the probationer once there's a violation. So we were well within below those dates. So in quarter one, we're at 8. So we're doing this in 8 days. And so then in quarter two, we're at 33 days. But what happened was, thanks to Jocelyn Campos, discipline coordinator, so what happened was we identified it that the wrong entry codes were being entered into Breeze, to the system, and the wrong dates were being entered in the Breeze. So we were still within those target dates, but we entered inaccurate information. So what we did is, how we addressed it was we had case cleanup, and the discipline coordination unit did that. They started cleaning up the codes. We had training with all the staff, and once we identified that through the training and the cleanup, quarter three, we dropped back down from those target dates. So we came back down to 12. So again, we're well within our target dates. So that was kind of the highlights for quarters 1 through 3. So if anybody has any questions. No questions?
Carlos, thank you. Sounds like we're going in the right direction. Thank you. Board, any comments, questions? Public comment?
Thank you.
Okay. We're on item number 24, licensing certifications permit committee report on closed session. Dr. Lai. Lai.
I'm not gonna give you the report. I'm just gonna hold for half an hour until you get my name right.
I'm not tired.
Okay, license certification permits and committee met in closed session to consider 19 candidates for issuance of a new license. I think that's the most I've ever seen, to replace cancel. The details of the applications were included in committee members' closed session binders. The committee recommends taking action on these recommended groups. In the DDS category, so I'm not gonna mention names, but initials. Doctors LB, LD, JJ, EK, GS, all need to take and pass the California Law and Ethics exam. Dr. TD will have to take the California Law and Ethics exam and pass REB, or clinical exam, prior to licensure. Dr. TT has failed 2 separate attempts to pass his exam for the reissuance of a conscious sedation permit. His permit is immediately suspended and denied at this time. He can apply in the future. In the category of RDA, the committee recommends the following actions. RD applicant RB, EL, CO, JL, AM will need to take the RDA written and law and ethics exam. For applicants KS, LD, PB, granted reinstatements of their RDA license without restrictions. For applicant MT, 2 hours of infection control with the completion of 2 hours of infection control. That's applicant MT. Applicant NB, incomplete CEs, incomplete 2-hour infection control, incomplete written law and ethics, held until completion. Applicant TB, incomplete CEs, needs RDA written and law and ethics and BLS. For applicant IC, incomplete CEs and BLS, held until completion. So at this time, I know we try to get completed applications to our committee, but sometimes it's difficult because it was explained to me that sometimes it's 3 or 4 months before the next meeting. And so we just want to move these people along, either for financial issues or just not being able to get certain classes. So we try to give them a little leniency. So with that, I would like to humbly expect the full board to accept our findings. Take a motion.
So moved.
Second, Burton.
Witcher.
Excuse me for a minute. Michael wants to add something.
I don't know if this was brought up before, but this was a recommendation from committee. So recommendations from committees that come to the board don't need a motion or a second because that's already the motion. So all you need to do when you have a recommendation from a committee is to take public comment and then you can do the roll call. That's Robert's Rules of Orders. But again, if you don't want to do that, that's certainly your call. That's just to save some time for the record-keeping purposes as well.
Oh, no, we want to do that.
I'm going to go by Mr. Santiago's recommendation, please.
Can I ask for public comment? Seeing none.
No. Thank you.
Burden. Yes, okay, Chan. Chappelle. Lay is absent. Lauren?
Here.
Lie.
Yes.
Ooh, okay. Mackenzie is absent. Medina is absent. Uh-oh. Mara is absent. Allergy. I'm gonna practice that. Picacho.
Pacheco. Pacheco.
You guys are gonna love me. Stewart.
Got that right.
Witcher. You. I love your name. Passes. Roll call. Okay, that's it.
Thank you, Ross.
That's the
Yes,
roll.
come a long way.
Put it down as roll
All right, I think we're on item number 25, public comments on items not on the agenda. Seeing none. Board member comments on items not on the agenda.
Yes. Yes.
Ms. Burton.
As you recall, Dr. Lay and I are on the Oral Health Committee. We've been notified that the Oral Health Committee is having a summit on June 19th and 20th. The purpose of it is to launch the California Oral Health Plan for 2018 through 2028. And also to make sure that all of our partners are working together on issues. So that's June 19th and 20th. We both have responded and will report back at the next meeting.
Thank you, Fran. Excellent. Further comments? Dr. Chan.
This is for a future agenda item again for the issue of orthodontic treatment by correspondence. Just as an observation in the marketplace, in the San Francisco Bay Area, there's a BART system, a subway system, and goes all the way around. At the major hub where all trains have to pass through, there is one area where there is more than 12 billboard-size advertising that service. And you have to go past this hub to get anywhere around the Bay Area. Of the three major cities in the Bay Area, San Francisco, Oakland, and San Jose, there are buses with the billboard-size ads in that area also. For a future agenda item to discuss.
Thank you. So noted. Further comments? Dr. Lai.
I think last year, Dr. Morrow brought up the faculty teaching permit. Is that on the agenda? I guess we don't have a faculty teaching permit for out-of-state, out-of-country faculty, and whether they are qualified to teach in a CODA-approved school. So that we talked about that. So I think we need to bring that up again.
Sarah, do you recall what happened with that? I don't recall the board wanted to move forward with any further discussions, but we'll go, based on your request to look at that again, we'll go,
I don't know.
yes.
Yeah, okay.
So based on your request to look at it again, we'll see when we discuss that and whether or not we can bring it back for a future agenda.
Okay, thank you.
Further comments? Seeing none, let me just thank the board once again for being such a great board and doing the job that you're all so well prepared to do. Thank you again for our new members. We're excited to work with you and we're very happy that you're with us, and so we look forward to working with you in the future. And
Before you close,
and to our public for hanging in to the bitter end. Thank you so much.
do you want to recognize Dr. Lay's wife and son who are in the audience?
Dr. Lay, Dr. Lies. Oh, you just did that to me again.
Did?
Yeah, you did. Dr. Lai, I think you have some
Guests in the
family
audience?
members in the audience who would like to recognize. It's your privilege.
I didn't even see them there. It's my son, Mark, and my lovely wife, Anna. And they allow me to do what I do here,
Awesome.
because they make my life a lot easier.
Welcome. Thank you. Thanks for
And
being here.
Mark, you should be at home practicing. What are you doing here?
All right, with that, this meeting is adjourned.